and have planted in every nation of the world. We continue to ask for your divine grace, your divine mercy, your divine love over each and every human being in every part of the world. That peace, that love, that care and concern for one another will be uppermost in the hearts of all humankind. Particularly, we pray especially for those who governed, that they will govern with patience, with humility, with justice, and with righteousness. And so we continue to submit the TRRC sitting under your throne of grace this morning hour. Submit the witness that will be before us, that you grant him the boldness to be able to speak the truth, and grant the commission the discerning spirit to discern between truth and falsehood. And we continue to ask that you grant the populace, the diaspora, and the international community, grant them the extraordinary patience to allow the due process to take its proper course. And you, being the just judge, will reward each and every one accordingly. This we ask through Christ our Lord. Amen.
Amen. Thank you very much, Bishop Odeko. Council, I believe we are continuing with our focus on the justice sector institutions. That is the case, and you're ready with the witness this morning. You may please proceed.
Good morning, Mr. Chairman, and good morning, commissioners and members of the audience. Yes, we are ready to proceed with our next witness, and we are continuing with the justice sector reforms today. Thank you.
Thank you.
I, Bori S. Ture,
I, Bori S. Ture,
do swear that
do swear
I'll speak the truth,
that I'll speak the truth,
the whole truth,
and
nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you.
Good morning, Mr. Ture.
Good morning, everyone.
Sama, Mr. Ture.
Good morning, Isama.
Isama.
Isama, alhamdulillah. Good morning, commissioners. And good morning, members of the TRRC.
Alisama Commissionalu, Alisama TRRC Nkolu.
Thank you very much, Mr. Ture. I have the singular pleasure of welcoming my learned senior today before the commission.
Thank you so much.
Inumbara.
We thank you for honoring our invitation at very short notice.
Mbe numbara la nge kumandi wati sutun kono inate danku.
I'm grateful indeed.
And I also have the unusual opportunity and privilege to guide Mr. Ture, who is my learned senior, in his testimony.
And hanin kabi nyinketanye site sewoti ame alonko aman dari kake puru ngatambi na nyaronko nyaro puru me alonko loya la karola puru ka tete nyi sedandro nyinkon.
I'm grateful indeed.
Aketanyeng nyaboti.
Please make yourself comfortable.
Mbe danila ifansindi yafansoro.
Okay, thank you so much.
Inumbara.
And during the course of your testimony, keep in mind that we have interpretations going on in the background.
Mbe hakilo bulanda fanan sedandro nyi wicho nyi kono kanna soro be kering sansan kono jana nim bantala pour isi hakilo tuwaro.
I'm grateful indeed.
Aketanyeng nyaboti.
In your testimony today,
Ila sedandro kono bi
we would like to hear about your experience as a magistrate,
belaf la pour ka moy fan bulu tumala menna emu kiti telade dumalankoti ba fala me magistrate.
You were a former magistrate just after the military government took over in 1994.
Iketa kiti telade ba fala me magistrate tariyaren ke kabrin mansakunda fala ngera memu tuta 1994 coup d'etat bodala.
Focusing more on political interference into the judiciary.
Andung be nyatil na bake men kono wala ngindi ko politiko la karola ke dabula judiciary men kete kiti bundal la fannati
By way of executive directives, intimidation.
andung aka ke nyame wala ngindi ko kangola kam bonan santo wala mansakunda la santo la bala multi kana ke dabula ko nyin kono
Show of power and force and other undue influence.
men yala ko e kana semboning aninka kangota mandi
Consequently resulting in human rights violations.
men nata na nyala banke hanama di nyanta tinyala ko nyin kono.
And in doing so, we will explore the following areas.
Andung kawo ke mbelafla nyim fannal lel kachala.
We would like you to tell us if you know or if you have experience and how JAME used the judiciary and other justice sector institutions
Belafla ya fonye ninga ya tara ya long ya jamme aka tilingo bunda aka ndabula di nyadi le andung aka tamandi du nyadi le purka ala kango tamandi je.
such as the Ministry of Justice,
Abe kono ministry me marre luwa lin kirindir kunyala
the Gambia Police Force,
na polisi kunda
the Prisons Department,
na kasabunda
to achieve his own personal agenda
nyin kamala ate fango ate hamen ko mendiron purka otimmandi
and thereby perpetuate and entrench himself in power.
nyin kamala puru asate ate le sembor ron ate system me sembor nyame purka fan kasupura sulo dun sembor.
How JAME used punitive laws
Jamme munafan ni luwa kurungol la nyadi le
to persecute his political opponents, critics,
puruka adonyol me alonko wala ma jawol ti ala mira lo puruka wol kitindi ke dete
and other perceived threats to his administration and power.
anu ngatele jikoro wala nyindi dolbe kala maslangol ti ala semboto anen ala maraloto
And how people were routinely, falsely, and maliciously prosecuted under the criminal code using such laws.
anu akeno ta nyadi le mol me alonko igana tumiro le kan faniya kono me alonko anen tilim manta purke kitindi tilim baliya kan menni luwa manta luwal ko luwa kurungol ko.
We would also like to know about the abuse of the Ministry of Justice
anen kabi mbela fla fanan ka lo ministry member ni luwal den kitindir kunyala lanna tambol me alonko wala kete la fannala.
in particular the manipulation of the Office of the Director of Public Prosecutions, DPP,
Andu abe kono wolem director me alon ko wolem marlin kitindir lal bela nyaton ko mebe ministry me marlin walin kitindir kunyala me alon ko ika yelamandi ila kul yelamandi nyamen ka kenyala me alon ko wole bate di ala diani ko ti kawti mandi
in order to target political opponents
yin kamale saja ala jikoro menu matela opposition wolti pour kawol dalin ka kulawol kan
through politically motivated prosecutions on bogus charges.
Andu kaka nyame wolem nyindi ko ka politika tumiro la mol kan ron politiko la karola isaje nyin kamala telafta menaron pour ka timmandi atela karola.
After you became a magistrate, you went into private practice and you have extensive experience as well.
Biringi kibota ka ke kitindir lati dumalanga kitindir la ba forme magistrate inata na e ura ikitata na to do ko ke ifaye andu ila do ko nyin kono elondi sahari ngosota do ko nyin kono le
On some of the criminal and civil cases that you took for clients.
andung ika kesiso dol men dame alon ko dammani damma kesiso le modi ba forme civil matters dol be je on mukuriya kesiso le ka forme criminal yewta kilianol toyala
In which you witnessed human rights violations as well during those cases.
Da mente yalon ko ila o kesiol me alon ko yeta ila kilianol toyala ya hanabadi nyanta tinyal men je kuol kono iso fanam fo.
So we would look at perhaps imposition of unrealistic bail conditions, for example.
Aning hani kabi fanam ba fanna do jubela memo bail la karola ti me alon ko abukata ni tilingola silola.
and the blatant disregard for established, court and legal procedure.
And wala nyala fana me alon ko ka nyala kaso ke pour ka court la loi sirol ni sartol lande nyamen ke nya kaso la katani sila dola bo fana juwelale.
You also have extensive experience dealing with land matters.
And you londo fana soto wala nyin kene nyin damma kene fitinol fana me alon ko wala ka dum molda malte ma yelondo soto fana ko to bakele.
From the district tribunal all the way up to the Supreme Court.
Abon na yin sefu kiti bundal do kata fo kiti bumbala santon ko to mbika me Supreme Court.
If you have any examples of how the office of the sheriff at the High Court was interfered with and manipulated.
Ni ngaytara yellondo so do bundala me yalon ko be kiti ndir bundado e ba fala me sheriff division me yalon ko wolle be katara marale ni ngaytara kiti o e kunturo ke kula me yalon ko tamandiro nyana kelo bundar men ka ko nyin tamandi ni ngaytara londi so foro ko ikay muna fa office o fana na nyame pour ka sembola mul kan.
Especially in relation to the sale of forfeited property for the benefit of Jammeh.
Surtout abe ko ning ayatra kito e kundro ke ko kula me alon ko nyim dingira kar nyanna wafila le me alon ko sobobe je ko yaya Jammeh ay sulo sura ko nyin konole.
Bribery of judges and witnesses to secure criminal convictions.
Aninka jojol ta wolem kiti bunda santon ko kiti la santon ko de keta ke duku aninka kisedol ta fanan ka kudum ida ko no waranto ka fendila pour yena kuma fo me alon ko be diala mansaye.
And the removal of public officials who were no longer in the good books of Jammeh.
Jamala do kulal fana memo mansakunda do kulal te ke bondi la do ku palasol to nyin kamala ko ini yaya Jammeh mantra ni fanna keling mirodo.
We also have politically motivated constitutional amendments to entrench Jammeh in power.
Ko hannin kabi fana nga loi buku bani fana kono nga je fana je ko falindo dol keta jele me yalon ko ya ke dalilo men kam wala nyinde ko pour ya Jammeh ron ata dianye ko nyin pour ka o se won ka o tummandi ron ay o falindol men keta buku nyin kono.
And this is just a guide.
Ni mukule de ron pour nga fale ron pour nga ngete ala ila sedan ro nyin kono.
However, if you have other examples
hannin kabi o nyaawo fana ninga tre misalo dol fana soro
how the justice sector institutions were used by Jammeh.
Akeno ta nyaadil na tilimo bunda nying ye yaya Jammeh munafanga la nyaadi le pour ka kol tamandi je membe diala ate waranto memba tela ni dia nyin timmandi la
to achieve his objectives, we will be interested to know from you.
pour ka tela hamen ko nyin ka timmanda be la fla ka wol fana long ning aytre misalo dol fana be fana mbulu.
Thank you very much, Mr. Toure. If you're ready to begin, we will start your testimony.
Inumbaraba ke Mr. Toure silang ninga tarebe pare rimpuri le sedan do nyin damuda nsada damuda.
I'm grateful indeed.
Akitanya nyaboti kendeke.
Kindly provide your full name to the commission.
Dukare to ni konton fo molie ban commission ya.
My name's Bori S. Toure.
Nto momenti Bori S. Toure.
What is your address?
Ila address odum.
I live in Farato village.
Mbesiring Farato Sateoto.
And what is your occupation?
Amila do ko
I'm a barrister and solicitor of the Supreme Court of the Gambia.
Ndemu kiti ndirlani kiti bonyotolale ti Gambia la Supreme Court bundala, kiti bundala.
And what is the name of your chambers?
Ila do ko bunda nyinga todum.
My chambers is called Crown Chambers.
Na do ko dula mfansun dinkiranye kafuje ne Crown Chambers.
And where is it situated?
Nyin crown ila office on nyem Crown Chambers abe mindole.
It's situated in Banjul at the junction of New Primate Street and Boxbar Road.
Abe Banjulu New Primate Street ni Boxbar Road la sila kumbengoto.
Mr. Toure, you're a very experienced and senior lawyer at the bar. Can you tell us how many years post-call?
Mr. Toure ita mo molde me yalon ko yelondo soto andungi meta loyal len kafu ba nyin kono le faysa fono nyi sanji jelle tarta nyin do ko wol kono.
I have 21 years post-call at the Gambian bar.
Nga sanji mwanin clean ke do ko la bringa dati Gambia la kiti bundala.
Kindly give us a bit of your educational background.
Silang ila londo nyi kala karango nyi ya damura nyamen afanya bang.
I did my primary schooling in Sinchu Njabo Primary School.
Ngana primary karam ke Sinchu Njabo primary karam moleto.
In the North Bank region.
Bekere wan tundole kang.
Sabah Sanjal district.
Sabah Sanjal Banko kang.
I sat to the common entrance in 1982.
1982 sang kono long alundi kontiboke ikafome common entrance.
Then I proceeded to Nusrat High School.
Tata Nusrat High School.
I spent 5 years, 82, 87 in Nusrat.
Ntarta je sanjilulu kabo 82 kata 87 ngawle ke Nusrat karambungoto.
After writing to the O levels, I proceeded to St. Augustine's to do my sixth form.
Ringana O level londi konti boke ntata St. Augustine's kata na sixth form kije.
I completed in 1989.
Ngaw bang 1989 sangokono.
I worked briefly as a teacher in Nusrat.
Nga wati sutunke karandirola Nusrat karambungoto.
For 1 academic year.
Sanji kilinga ole ke karandirola.
And I also worked as a field officer in the Women's Bureau in the Office of the President for a month.
Nga karkilindo ko fananke musola office bala do ko bundala me yalonko. Welle kata bantala ka do ko le dinkirato ka fala mene field office and wotu mo jebe president wala office ole koto.
Then I proceeded to Frobe College, University of Sierra Leone, for a 4-year degree program to do LLB.
Ntata Furabe College me yalonka be Sierra Leone ntata na LLB ke wolto sanjinani.
I did my bar in 1995.
Nganna ba karango ke 1995 sankono.
That was my last exams in my life and I failed that one.
Wala mun nalondi konti bo labangoti na baluo kono bare wode manganye de mboitale.
I came down home. I got appointed in the government public service as a magistrate, first-class magistrate.
Seytana mbari nata do ko soto mansabunda la nketa magistrate fano kitindirlalti ikafome first class womu alodu la fololete.
Can you tell us what that means to be a first-class magistrate?
So fono nyama okoto mo munete ni ko inara na Gambia bango kanya inara na do ko soto mansakunda koto kake first-class magistrate okoto mo munete.
The magisterial bench was divided into 3 categories. You have the professionals who would be trained lawyers or who would have had their first degree, LLB.
Ya tala dinkira sabaleto kitindir bunda folo wala nyinti men ya lonko ye karandi han fo makama take men ya lonko ye karanta fo LLB soto wolmu anola leti.
And then you have the second-class magistrates.
Ye fanna fulanya soto ka fo men second class magistrate wala kitindir la bunda la lodu la fulanyangoti.
People who basically were retired and had a high degree of experience in the public service.
Wala moluti men ya lonko ye do ko ke bari na tay daha bari bitu ye londi saharin londi kono fa dum rim ba soto do ko nyi sambola karola.
And third-class magistrates, these are ordinary lay people who can be mobilized and then appointed to handle matters.
Nda sabanjango wala multi men ya lonko manke ko ye karambake ka londi bal soto bari mollemu menu la ko faramansata isita yolu fanalu londi o bunda to men ya lonko si jube oke tilingu nin to nya sambola kitola karola.
And then in 1998, I went back to Sierra Leone to do my bar again for the second time.
1998 muruta Sierra Leone nyin silo katanna ba sayin kanke kota ke sinya fulanjang.
Mr. Ture, before you move on to Sierra Leone, I just wanted you to give us the difference between the roles of the first class, second class, and third class magistrate.
Mr. Ture, jande be ta ka kuma fonye ila murunga sinya fulanya kata Sierra Leone lefta ka ya fonye wala mun fatam fansile be nyim first class, second class, third class magistrate muna be tema.
When you are a first-class magistrate, you can exercise all the powers vested in the magisterial court system.
Nimu first class wala makama folo nyinti woto sembe wo sembe nabe wo kiti bundala istesi o tamandinole ila do ko nyin sambola karola.
And in terms of the differences in their civil jurisdiction, first-class magistrates can handle matters to the tune of $1 million, claims up to the tune of $1 million.
Between first class magistrate palastiolu fanalu kito lulanya anin kolu kafute manyaming isi kito lutano le anin kubonyoto me ya lonko nin dépense bakono wala kodi kubakono men sita hanfo $1 million killing itelisio wo sarto lutano le.
Second class, up to a tune of $750,000.
Second class wala mludu la flanja unyenti wolu isi menu tano ning misali kama kodi kuo bakono men sita hanfo $1 wuli tawra wula nyong.
And third class, up to a tune of $500,000.
Unda sabanjango nying wala men ya lonko isi kuta mandi no ning kodo la karolem men sita hanfo $1 wuli tallu wulu nyong.
And I must also add that in the whole of the Commonwealth, the jurisdiction of magistrates, magistrate courts in the Gambia is the widest in the entire Commonwealth.
Commonwealth tundo mume obekang kuolu la nyante la Gambia tale kono fanuta bunda dolu da taluti men ya lon ko bebe Commonwealth koto.
Especially in terms of the exercise of criminal jurisdiction.
Sako kuolu menu tilinta kuruya kuolu bonyoto la ninga kitolu tamando.
Magistrates in this country can hear capital offenses.
Magistrate lu menu be nyimbanko kang isi kitindiru kunton kolu beta nole men ya lon ko wollem ku kurungulu kunton koti.
And Mr. Ture, that would be the first-class magistrates in particular.
First-class magistrates.
Yes. First-class magistrates.
Ha, well, first-class magistrate quality,
Because they had the power and the jurisdiction to hear more complex and serious matters than the second and third class. But just to be clear, during the time that you were appointed as a first-class magistrate, you still had not sat to the bar.
But Hanikabi Purja Senadron, Capri Yeta Tombon Keke first-class magistrate, Hanikabi email a back follow.
I did my bar in 1995.
Nanna back in 1995, Samalekono.
It was because of me failing my exams in 1995. Why? I had to come home to work on the bench in order to prepare myself for the second session, for the second sitting of the bar.
Ngawo ba londi konti bo folo menke wairi mboitele manganye ngwakilta nseita nang nata bencho to wala na kitindirla la si lolula puru nyin kamala ngamfam parendi koteke puru nyaton ton sina akono masata.
And I must also...
Sorry, Mr. Ture, for interrupting you. I just wanted to bring out the point that at that time, there was no requirement for you to sit to the bar as it is the case now.
Yes, you are perfectly right.
Council kai watembo amanke nyimukuti men kaninta puruka kulu tamandi mensike londi kontiboti bakaro la kosa inga benyami fatatale.
Kindly continue. My apologies for interrupting.
I'm grateful. Then like I indicated, I did my bar in 1990. I went for my bar second time in 1998.
Bitunata muru katana ba nyin no masata memwa sinya flanjanguti 1998 sangokono.
We were interrupted by the events in Sierra Leone because of the civil war.
Bitun kolu nata na karango elandi ka kuntu katuotumo damma kelo wulita Sierra Leone banko kang.
However, we completed the course, and in 2000, I was enrolled at the Gambian bar.
Baro nyawnyandinga katangal na karango to labang bitun hanfon seitana natana dung Gambia ba kitindir bundala.
And
2000 samokono.
I still continued service on the bench.
Bitung hanim bin continue ta do ko la bundala ka fudam ye bench wala menumu kitindir la silalu tije.
And over the period, I had a couple of training on human rights because I was a member of Amnesty International.
Bitu wo wuce okono nata karan londi karan fason fula soto me ya lonko aben adenta hadamaya nyanta kunya lela katu wotu mombe kafo kono kafo me Amnesty International.
Gender was also part of my training.
Musuninke tema fatam fansolu fanaluda benna karango konole.
We also did a course in Sharia.
Andu londi karango fananke Sharia kitindir kunyal tole.
That's my professional and academic background.
Wala mo na londo silolu ni makamo luti ngameno soto karango ni londo la karola.
In terms of your experience as a private legal practitioner,
where
would you say your expertise lies, or what kind of cases would you normally involve yourself with?
Let me also say this, all baristas in this country are general practitioners.
Makamo me kafaye barista. Meni ya lonko be makamo to nyimbanko kang wolube mu ateo kitindirla kilingol leti.
There is no one particular chamber that specializes in any one aspect of the law in this country.
Amunta bunda lori ntije ka foko nyim bunda kari nyim woluka bula nyim londi kar le noma wala woluka nyim londi kar le kitindi wo bunda lu mansoto.
That's due mainly to the nature of the economy, small size of the population. But my practice over the years got concentrated on criminal and civil matters, more especially land.
Ujama katilim banko fanko Kenya lela aning banko la doya Kenya fanan kama bari bitun tella kuolu noma sato on kabula menu noma bake wolem nyin kruya kuolti men yalon ko ikake ikana e finti ke iftande kiti bundala.
Taking your career in chronological order, you started off as a magistrate, first class.
Nia jube la londo ni ila nyati li nyanyi kelenya purunga bulanyo no ma nyati tilinda nyoye nyame ya follow diamond wala kitindir lati kafme magistrate.
Yes, that's true.
I would like us to explore the order of judicial interference.
Mbela fla purunga order for senade do mande wala kiti bunda ni na dabulo menga ka ko nyindo wato yobeje
by the executive into your work as a magistrate.
Andu dabulo nyinga ko bodame do wolle msandon kolti mansa kundala karola ila do ko nyinkono.
After you were first appointed as a magistrate, where were you posted to?
Briye tombon kuta keke kiti ndirla do malanko de ba fala me magistrate ye samba do ko la mindole.
I was posted in Banjul Magistrates Court.
Mbe Banjul Magistrate Court le nga follow jele.
At that time, who was the Chief Justice?
Wato la jumalam kiti ndirla be na nyaton koti.
The late Chief Justice Omar Al-Ghali.
Chief Justice Omar Al-Ghali.
He was a Sierra Leonean by nationality.
Atemu Sierra Leone banku dingoleti.
May I apologize? Chief Justice Omosun.
Chief Justice Omosun.
Omosun was a Nigerian.
Omosun mu Nigerian oleti.
Came here on technical assistance.
Natajang nyinkam ma praye makoiro tamandi do ko la karol.
Al-Ghali came after him.
Al-Ghali bulata atelenoma.
Okay, but generally, on the question of interference, may I divide the Jammeh era into two phases?
Jube, mansala dabulo kito nin kitindir kuoluto mbela fla katala ka ke fanna fulati.
Mr. Ture, before we just go there, I just wanted to know some of the key players in the system, like who the DPP was and who your principal magistrate at Banjul was, just so that we can get that context and background before we move on.
Much obliged. Principal
jannim bita wodo fola mbela fla kalon folo jumalle mu molti men yalon ko wolle fam daba ko nyin kono misal fe mbela fla kalon jumalle principal magistrate jumalle mun DPP di men yalon ko wala katara marling masa kundala kitindirla nyaton kola o sifal na nyongol mbela fla ka wala lon folo jannim bita wodo.
The principal magistrate in Banjul Magistrates Court was His Worship Magistrate Onya.
His Worship Magistrate Onya wole mu kunton kotinu wo kitindirla silolu la karola.
He is a Nigerian by nationality and a man of distinguished birth and a very strong character.
Atemu Nigeria banku dinguleti mole fana mu me yalonko atobota adu molem me yalonko ala kolu ake bambandi bakele naba atamandila.
Was he also here on technical assistance?
Yes, he was. He came along with three of his colleagues. Magistrate Sadiq in Kanifing, he was the principal magistrate, and Inyang was in Basse. He was also a principal magistrate. They are all Nigerians.
Magistrate Sadiq member in Kanifing, and Magistrate Onyang obenum Basse, bari telube nata osila kilimo la kan kitindro la karola banko kanjang.
At the material time, I believe it was the Attorney General was Mr. Marong.
Andu otembo nlata la ko tumo Attorney General moleti kafome Mr. Marong.
I'm not very sure about that, but I have a feeling that it was Mustafa Marong.
Amang ko imma baba bakere bari ngani miro soto ko tumo membije kafa ne Mustafa Marong.
This material time is what year?
It was 1995.
1995 sangole konote.
Yes.
I believe Mr. Fafambai was the first Attorney General.
Njikita Mr. Fafambai atela munu Attorney General.
Yes, that's right.
Masakunda falengo kera waro men.
So was this after he had been removed?
I believe so. I didn't meet Mr. Mbai in the office.
Kindly tell us what your experience was at the Banjul Magistrates Court, working as a magistrate under Principal Magistrate Onya.
Silang afonye bang wato menaita mukiti ndirlati me alon ko be ko ke kam principal magistrate Onya koto muna ketete la kulti men yalon ko yowlel karanga ko nyi do ko nyi konoje.
Okay, let me go back to the two phases of division that I would categorize the Jammeh administration into.
Ngata ngao fana fulo memfo alhakatu ko nga Jammeh la mararo wucheo kolu talanya mengake o fana fulo mente mbaranga muruje kan.
Yes, it's true. There was interference with the judiciary during the pure military era, that's during the transition of 2 years.
But
but it was far less in degree than what later came to pervade after he had transformed himself into civilian administration.
Barotumo akuo mansia asembo fana mawara baba bake ko anata laban nyaming biring ay sojari abula ay faling anata ke civilian oti anata dum mararo kono wotembole mkulu wajabita.
The government, the executive then had very little interference with ordinary civil matters or ordinary criminal cases.
Wotembo ko flodulato wotumo kunton konying alama kango doyata bakele kuolu to men keta o kuruya kuolu bonyototi aning moni motema kitolu fanalu lanyato.
Their focus mainly was on matters involving senior security and police personnel. Senior security, army and police personnel who were arrested and detained, and some of whom were being prosecuted.
Wotembo itelanya tilinta kuomena wala mbrim falingu keta ye police kebalu menu muta ni sojar kebalu wala kanto ni tankada bunda nyaton ko lu menu ye muta be dolu kitindi kango tumo itelanya tilinya keta wolela koltinu wotumo.
So my first experience in terms of interference was when the case of Inspector General of Police versus Pasala Jain, Ibrahim Chongan and Keba Diba was assigned to my office.
Amunta ntela londi follow kuolu tamandi nyato dabulo la karo la kitoto waketa watu ulti bring kito futatama Inspector General of Police Pasala Jain ani Ibrahim Chongan briwo lakko nata kafutama
and Keba Diba.
Nin Keba Diba.
And Mr. Ture, just to give us some background before we go into that particular case, give us the context, especially with the passing of some of the military decrees at that time, what the effect of those decrees were on the laws of this country, especially the Constitution, before we go into the facts of that particular case.
Bunda lua bundi government decree mo decree nying anata na mun kole akule sabu ko nying kono janni be constitution nying londila.
When the Armed Forces Provisional Ruling Council was being created,
Biribe AFPRC lawo council bunda londila Armed Forces Provisional Ruling Council.
They promulgated Decree Number 1.
Certifolo dada ekafome degree number 1.
And that is the Armed Forces Provisional Ruling Council Establishment Decree.
Walem sarto timmeye Armed Forces Provisional Ruling Council la sarto wale bunda fangolondi.
Sorry, may I apologize. The first decree was the Constitution of the Republic of the Gambia Suspension and Modification Decree Number 1.
Al haketu filo ketaje decree follow nying wala mi banko la sambarang sarti bukuba nyin ne fangola kolu follow falling we ka fole constitutional aning itele lafta kolu menu tamandila je.
By this decree they suspended the whole of chapter 4.
Bitu decree ya sama ayasabu constitutional la sapanani njangu mumeo be chapter 4 yo be denne.
And this is where you have the entrenched and protected rights conferred by the Constitution, fundamental human rights.
Adum wole mu bundati meye hadamaya nyantolu be londi ke bambandi me yalon ko wole ka hadama dingulu kanta ila baluwo kono amunta italio bunda nyi mumeo bele demfolo.
So the junta gave itself power to arrest, detain anybody for any length of time.
Junta nyi ngolem sojar marabunda ye sembo di ifangolula iteli lafita momondi marala wala lafita momondi mutala isi muta ye sindi fojan ning wati mendiate tole nyawnyandi nyama.
And also they arrogated to themselves the whole of corpus of the executive and the legislative power of the nation.
Bankola sembo kabirim mararo la karola fokuntonko fanan sembo la karola anin kata kito fanalu lanya bunda tukumu la karola yo sembo bechika ya di fangulula.
And Mr. Ture, sorry, just so that we can understand before we move on. So all of those protective safeguards that were in place during the criminal justice system for accused persons were no longer available to them at this time.
Amunta pour mo tumiri mo o mea lonko tumiri mo lam pour ka même loi men nyanna ka tankandi ka tankandi olbe mu kulel me alonko olbe man raw tumiri mo e kotange olbe bondi jele kota.
Yes, that is right. You can no longer as a lawyer go to court and then file an application for the release of your client who perhaps has been arrested and detained.
How muto nyalti ni mu loyati wotembo fonga ititano la kiti bundala pour kata safero kije pour nimmo mutari ngo bije mem itela kiliano ti pour isio bula nyaming wotembo loya ma sembo soto.
The stage was set. The stage was set for imposition of dictatorship from the very beginning.
Amunta wotumo lem yelondiro ke kasulo dundi sartolula me ya lonko wolle be tajreya aning sembela mararo londi la nyimbanko kan.
So there was no right to liberty per se, the right to bail, and the 72-hour time limit was also not applicable.
Wala mnyintiko hanamadi umoma nyanto soro fai puruka fansoro andung puru bail fanang na karola fanana na kolea kuonyinkono.
That's absolutely right. All notions of rights and freedoms were suspended.
Umuto nyalte bitu molla taram fambulo fansambo aning ila kolu Kenya mfayo yolu be kafunyo male utumo ye deng asembo te mola.
And what did that what effects did that have on the rights of accused persons, especially if you try to juxtapose that with the case of IGP and Pasala Jeng and others?
Wona na mun kolea kulle sabu tumiri molla misal fe surtout ni nata na sawndi yana misalo di IGP Pasala Jeng anado nyol la kesi nyinto.
May I give a bit of a background history here?
Please go ahead.
Before the case file was assigned to me, there was a lot of battle between the defense team and the prosecution team for the bail of the accused persons.
Janning kito fonga be dilantela nyo sababale tartaje nung kitindir lalu aning loya do lutema menu be lori ngi muta moliye akete mo nyo sabale tinung karaning karatema janning kito nyimbe chikala kadintela.
And the trial magistrate Onya, who had conduct of the matter, ruled in favor of the prosecution, denying the accused persons right to bail.
Magistrate Onya me ya lonko ko be lari ngatele bulu nung ay nyi sembo tamandi je kabalang pour ka nyi molu bail menu be loyal membe lori nyi moli nung amunta ayolu korindi jele amanson pour nyi molu han kiliye bail ikono.
And was that pursuant to decree number 1?
No, that was not pursuant to decree number 1, but other follow-up decrees.
Wo amanke ko be dendin decree follow nyin la de bari bitung decree dolu fanalu nata fintile men ya lonko wolio dinkira bambandi.
In particular,
sako membe ko
you have state security detention of armed and police personnel decree 1994. That's decree number 3.
Sako sarti sabanja umen inata afintindi 1994 men tilinta molu mutola menu be kantonin tankada bunda dokola wolem policeul men ko menu be security wala karola.
And I believe this particular decree affected these particular accused persons because they were military personnel.
So munta mfele ko nyin decree ni kay men decree men nakmo foten anata na nyin tumi mol nyin batandi bagal me alon ko tanko bunda mol. And
their names were specifically, I believe, gazetted in the decree.
Andu itol nyi na ne tol nyin kuson son leila in gazeto nyin to ka korosi.
That's quite right. Pasala was from the armed forces. He was later appointed as Inspector General of Police.
Umuto nyalti Pasala atebota kanto nintankada bundale la dunkokola ina atake Inspector General ti Police la
Ibrahim Changan was a Gendarmerie officer and Keba Diba as well.
Ibrahim Changan atanin Keba Diba itulbebe Zandam bundale la nundokola utumo.
They were later transferred to the police when the Gendarmerie was being dismantled.
Ina atesa undi kenaiti police bring ibe so
legally speaking, Magistrate Onya was right on the law as it was.
Magistrate Onya
in refusing to grant them bail. There was an application before the then Supreme Court, which is now the High Court, for bail.
The Supreme Court member High Court bail
and the Supreme Court also upheld the position of the magistrate that he doesn't have jurisdiction to grant bail.
Adu bitungo kitibunda santonko nata londi magistrate la okangokang ko aman sembo soto purka bail di molula.
So it was after all that skirmishes And after the transfer of Magistrate Onya from Banjul Magistrates Court to Kanifing Magistrates Court.
Andu inata Magistrate Onya saundi kabundi Banjul Magistrate Court kasamba Kanifing Magistrates Court.
Because the state had intractable difficulty in getting decisions from his court going in their favor.
Puruka kangulu soto atela kiti bundala kangulu meni ya lonko wole mansa nyatonko mansa kunda fasa anu otumo.
They had to re-engage one lady by the name of Mrs. Scott, wife of former Liberian ambassador to the Gambia.
Inatamola makwero nyining Mrs. Scott meya lonko inatate dundikolu kono andu otumo Liberia bankola ambassador membe nyimbanko kangole la musomu o marioti.
Mrs. Scott came here on technical assistance as a magistrate from Nigeria, and her maiden name was Miss Ogojafo.
Anatanu jam doko silo menna wolem kana makoiroke wodoko bundala bari abinatu mo menna utumo to men ka foye ka fole Ogojafo.
At the end of her term, she decided to stay on contract.
Bari birala doko keta hanfo awucheo banta nyinata dunga fango kono prasi tujang ay continue doko la bari wo katarta contract ko le kono.
Along the line, she got married to the Liberian ambassador.
Bitungo wucheo kono lem anata futu Liberia la ambassador e membe Gambia jangutumo.
And the Bar Association petitioned the executive that you cannot be a spouse of a head of mission designated to the country in question, and you'll be allowed to function in the public service of that country.
Bitumba nata nyinsafero ke ko te kenola ite kenola nomonyoti moye me yalon ko mu ambassador le tinyimbanku kan wokola ite me mo mari la nomonyoti yena o silo soto ka o makamota pour ka do ku façon ke banko kan ikote kenola.
At that point, can you remember who the president of the bar was?
I
did not join the legal system then. I was in the university.
Wotumo mantara luabunda do kola otembode mbe university oltunu ngotumo.
But it must have been between Surahata Jane and Hussein ONM Dabo.
Otembo abetarla mo fulale tema Surahata Jane wala Hussein ONM Dabo.
So following this petition, Mrs. Scott was obliged to resign her position as magistrate.
Birinkiti bunda yo kanindiro ke yo safaroke bitu Mrs. Scott fere mantuwa je faye dahadu ko nyinna.
The Liberian ambassador became the dean of the diplomatic corps, and because of that, she had close personal interaction with the former First Lady Tutifal.
Bitu tumo Liberia la ambassador le natake ambassador dolu bela kunton koti Bangkokan ikafole dean bitu kamala alawo nomonyo anim banko president la nomonyo la kulu nata katanyo la foi futata nyoma wotembo Madame Tutifal jamme wala be futu wala president.
I must also add that Mrs. Scott was a very highly vindictive person. She had a lot of difficulties with members of the private bar.
Mbenyim fanan la fala je ko Mrs. Scott wotembo mole me alonko between nyin kuolu ka kuolu noma sata julujo kan wakadia num bake andu wale asabu aning kitindirla jamali kole ya kosoto meni alonko ibe banyi na karola utumo.
So she got Tutifal to convince Jammeh that if she was reappointed as a magistrate on the bench, there would be difference in Banjul Magistrates Court. The state was going to get convictions in its favor.
Bari anata kata ay fero ke hanufo ay ngani oning hammo dundi akafunyo kono memu president la musoti wotumo Madame Tutifal Jammeh pour wo sidia mu akemae nyin kanko ni ate murundi na wo kiti bundala mansa kunda ka kole ya kolu menu soto num e wo kito la karola puruka ite langani ya kangolu tamandi akobe bolale ibe amunta mansaba angani yo soto na le kiti bundala utumo wala Banjul Magistrate Court kiti bundala.
So the junta reappointed her as principal magistrate.
Bitung sojar bunda na ta inkanta aketa magistrate kunton koti principal magistrate
and forcibly transferred Onya from Banjul to Kanifing, and she was to take charge over all the sensitive case files that Onya was handling at the material time.
Bitu watembo inata Onya force to saundi ka bondi Banjul ka samba kani fin kiti bundala bitun ate men ate ogo jafo men ya nati je bitun silango tumo le ngabulo nata la failo lu nin kito lu kan men ya lonko magistrate onya be wolle tamandi kanum bitun ate nata si wolle kunna.
And would you agree, Mr. Toure, that that political appointment was a direct interference in the judicial system?
Certainly it was. It was.
Political karola ke dabula kiti bundal no mu kula me alon ko bantambil bu katara wotonu o watolan
ha wo mu koleti wo mu bantambilo le fangoti ka o katenati ka adundina kiti bundal.
It was clearly a violation of the Geneva Convention on Diplomatic Privileges and Immunities.
Adu wo fango ay sarta dole tinya sarto me alon ko dunia be kambenta wole la bunda bala ye mellondi nun Geneva Switzerland banko kay ka fole ye Geneva Conventions nyin sarto be lorin woleto bari amunta itellate tombongo woyo sarto tinyale.
So when she came, there were so many files.
Birana file jamal le bijenu ngotumo.
Mr. Toure, I just wanted us to just go a little bit back and tell us what the source of this information was, the information about how she became politically appointed.
Mr. Toure selenga murko ma do manding ta fanya bang nyin kibaro nyin aketa nyaadi le ka fu akeno ra nyaadi le fu inara na nyinta ya murundi do ko la politiko la karola politiko silo men da fo ya murundi kana do ko la kotake ka ke magistrate woti.
At that time, I was not very much connected to the establishment. But Magistrate Onya, who was with me in Banjul Magistrates Court as the principal,
bari Magistrate Onya ni membe nyo bala nung Banjul Magistrate Court ko ate mukitindila nyaton koleti
had a very close relationship with the Nigeria High Commission and with the Ministry of Justice.
Ay chokinyola sutunne soto anin Nigeria la High Commission tema anin Banjul anin minto
the Attorney General's chambers.
Attorney General la office onying.
So news that Mrs. Ogojafo was going to be appointed as a magistrate
kibaro me ko Mrs. Ogojafo ba tombona le kake magistrate
reached us well in advance of government taking a decision on that.
Wo futatan teluma juna le hani janni man sakunda ba fang akonyin kela.
And how it was all generated, we also got the information.
Atamata nyameng akolu lata nyameng wo kibaro lu be soto otumole hani janna be kela.
Yes.
Thank you very much for that explanation. Kindly proceed.
So she then became seized of all these files, and then for some personal reasons, and that's by virtue of some relationship between herself and the former Inspector General of Police, Pasala Jang.
Bitung anatake moti memmarata o failo lubela anin kolu meni alonka yetaraje bar bitum fanan kolu lanya anatake nyintiko anin mola kolu takita nyola me alonko wala kita moti ka fa me num Pasala Jang,
who was accused number 1 in this particular case.
Me alonka telo motu mirim folote nyin kito kono.
She had moral difficulty handling that file in particular.
Wo keta ya kole ya kote afango sondo mo miro la karola purka o failo tamandi.
And that was how the file was assigned to me to deal with it.
But
the government itself at the time was not aware of that decision. So when I was assigned the file, I went through it, I came to discover that there were 52 adjournments on record.
Biringa failo nyinta ndunta kono ngala kulu kesemeti. Ntata tarako sinya talulu nimfula ikakito nyimama ndika deng.
And on all those occasions, it was only on one day that a real trial started. That was when PW1, the first prosecution witness, was invited to commence his testimony.
Aduwo kita sinya talulu nimfulo be kakito deng. Sinya kilin namu ye kuonyin kito fango diamu andu wolungulemu lunti meya lonko sede folonyin nata finti kadiamu akuonyin kono.
And what was the reason for all the other 51 adjournments?
Sa muna dalilo bakang ka sabu meya sabu fonyin lung taluluning fulo be ka lungoli sounding fafurata for. Muna dalilo di.
There were many factors. One was applications relating to bail, adjournments, arguments. That was part of it.
Kujamale be dendingala bare bitum bel kuolu kitola dengo kenyalo an India molu membe dendingala wolu bebe akonyin kono le wotumo.
But nothing of substance happened.
Nothing of substance.
Para manke kukumati.
So I then issued notices and gave a date for matter to be mentioned in court.
Bitungo tumole nata molu kala mutandiroke andi ngakango di fanang lumeng akobe fola kitibunda nyina.
Notices were served on both sides.
Nga kala mutandiro samba karafulo lubela.
And then we converged and we took a fixed hearing date.
Mbenta bitu tumole nata kambenga lumuta lumembe kala akuo lungo diamoti.
Now, on this day in question, the state did not produce a witness.
Bitu lungumenga taonya lumeng komba akuo diamula bitu mansakunda mandan sede fintindi membe lola akuo kono.
Can you tell us who the prosecutor in that case was?
He was Lamin AMS Jobate. He was then the Assistant Superintendent of Police in charge of prosecutions.
Wotumo Lamin Jobate lemu kitindirlati, wotumo atelefona mu Assistant Superintendent Police la Karola, amunta konyin dunta atelebuloko no wotumo.
Is this the same Lamin Jobate that appeared here on the TRRC, previous Minister of Justice?
Yes.
Lamin Jobate
He was a lawyer who was on secondment in the police force, and he was in charge of all prosecution matters.
Atelemu loyati yemenna do ko samba police la Karola ndun kitindirolu be nyan natata atele la Karola.
So when we converged to hear the matter, the state did not produce a witness.
Brimbenta purka kuonyin diamu mansa kunda manna sede fintindi.
And we asked him what was the reason why they were not proceeding with the matter.
Nga nyinin ka muna na itelu mantara tenten kan kuonyin na.
And we were not satisfied with the reasons that were advanced.
Adu itel nata dalilo lumenu fontelie wolu manke dalilati meyenteli nyafa.
Because majority of the witnesses were police officers working within the establishment.
Katu mo jama membe itel sedo lukono emenu fo wolu be mo police leti menbe do ko la bunda nyim fangoto.
And most of them were, in fact, at the material time at the police headquarters in Banjul.
Adu tembo fango wolu jama bebe kono ibebe do ko la banyunu police korda ba nyim fangole to otumo.
So it was like taking the court to ransom. Because
there was no justifiable excuse.
There was no justifiable reason. My personal impression was that because the case has continuously been adjourned, so that trend was going to continue. That was the prosecution's attitude.
So what position did you take at that point?
The defense lawyers made an application for me to dismiss the case. And I can remember there were Ms. Drame, Usman Silla, and the late Pap Chasin Seka.
And by Ms. Drame, you refer to Ida Drame?
Yes.
Ms. Drame, Madam Ida Drame.
So by the time Mr. Jobate realized that something momentous was taking place in court, it was almost late.
Mr. Jobate binajela kohe kukuma bale pareta kela kiti bundala baru utumu atela karola tardeta lede.
So they thought I was going to adjourn the matter again for ruling. I insisted that I was going to deliver the ruling the same day.
Itele nyine mutanunko mbe lundole mutala kota ke lumme mbe kito nyintela. Bari mfana lota nyine kanko ulungu fangole mtebe kito nyinkela kate.
So I went into my chambers whilst I was writing my ruling.
Ntata na ofiso kono mbena kango lusafe kango tumo mbe kango mentala.
A whole truckload of soldiers were deployed in Banjul Magistrates Court.
Ye moto fa mumeole nati je wolunga bemu soja rolti ye nati Banjul Magistrate Court.
It was like a military camp.
Amunda wolunje bele ko sojar campo.
Some of them, in fact, entered right inside the courtroom under the roof of the court.
Jama fang sotonta menu dunta nan kiti bunda fang nyin kono.
And were they armed?
They were all armed. All of them were armed. They were not, in fact, with riot gear. They came heavily armed.
Misal kama ningere wala keta wala balambaya ke fankanta jona wala mena ni wala manna itel nin kidol le nata
when they came combat ready.
Inata le ko molu menu pareta kelo.
Yes, it's like if you are deploying them to the battlefield.
Amonda inata le ko menu pareta tala kele wulo kono.
So when I entered the courtroom with my ruling, I asked all the soldiers to go out.
Bitunta nata dum kiti bundala ninna o sarto lu menu ngesa fe nko sojarol be finti banta.
They had no choice. They had to leave the courtroom.
And
I must also add that these three gentlemen went through a great deal of trauma. Because I observed for long when they used to escort them to court. Under the roof of the court. Wherever they are seated, the soldiers will be standing, pointing the nozzle of the gun against each one of them.
Kato hanni molu be sirin dawoda sojarol kay bayndi nan ka loy ikunto kiti bundala ando ngabukadang lo kunto la de e ka kidole fongo datli nyimmolu lay be sirin dame.
But when the matter was assigned to me, that was the first thing I said I wasn't going to countenance.
Mr. Ture, that position taken by the military or by the government in sending armed soldiers to the court was, in effect, an attempt to intimidate you.
Woto Mr. Ture o masakunda warando sojaro kundaro yo baro menketeng puru inaje ka sojaro kina je nin kidoldu ina kidi bundaro o mu kula me yalon ko inata la pur kete fananke silandi.
Yes, that was part of it, but also there was a security aspect of it because they were afraid that I was going to release them on that day.
Woda bijele de bari kanto la karado fananda bije wala mindi ko sobeta ko asikeno ntenga nyimolu bula wulum fango ke bula ye fansoto.
And members of the family who were there too were prepared. If I was to discharge them, certainly there was going to be a big showdown between them and the security. People were just fed up.
Nyimolu fanala badingolu bije ila dimbaya lu bije andu wolung ibe pareri ngol fanala pareri nyina la ni yebula abe kelama mambale tinunje wolung katwotumo molu fasita ifasita kuola ferengo tumo.
Were you intimidated?
Yes, ilandila baita fangundo.
Far from it.
Jamfataola.
I drove them out of the courtroom and then I proceeded to deliver my ruling.
Mr. Ture, I'm very interested to know why you were not intimidating under such circumstances. I think any reasonable person would have been. Can you tell us from where you drew such courage and boldness?
Well, Mr. Ture afonyeng muna keta dalilo tinung meyete juso bambandi aye hanyindi puru ka okota mandi wonyama wolun katu ni momondi ndolu abekele kijate oleti fangi silang wo molu wo joranti olula naje kama.
I think it's mainly because of my nature.
Ngamira follow ndanya wole muku followti nsiofo.
I hail from a very difficult father. It's not somebody anybody can easily intimidate.
Nde fama mu moleti me yalon ko ke kolembale mu adum purka silandi wo mu kuleti me yalon ko bukana mamandi fang mo buka silandi no.
And I remember the day I was appointed, I came home with my appointment letter. I showed him.
Lummen hakilo baka yen tombon ka nyindo ko dinna mbese la suwo kono tumo menna ninna letero nata nyola le tembondir letero me ya dinna nata mfutatama.
He asked me to sit down.
Akonyen si nsita.
Said this your work is different from every other type of work in the public service.
Akonye tela nyindo ko nindo ku dolu be fatata le mansa kunda do ko bundala.
Told me, he said, for every case you preside over here,
akonye isita kiti wo kiti kunna jang.
God the Almighty is going to preside over the same case to account for the righteousness or otherwise of your decisions hereafter.
Sinyilonko mansatalla Allah subhanahu wa ta'ala itebe kito tamandila nyaming ate mansatalla fanambe ebo kito tamandila wole nyama woto isi haklo tu tukunguluto nibe kito nyinkela.
So he told me, don't ever be afraid of anybody in the system. Do what is right.
Akonye woto kana sila mo womondina nyin bundala nyin doku bundala karola. Mentilinta bulawo no madron yeto tamandi.
But quite apart from that also, I was in Sierra Leone and I've seen war from another dimension.
Adung hana manke o damanti mbenu Sierra Leone nyinkelo damu tatanyala jele mga kelo sede ya nyayaje kelo fanang na kulu koleata nyaming.
It's much more difficult to deal with the police than to deal with the army if only you understand their psychology.
A koleata puru inim poliso liye kudu nyotema wala koleata inin sojaro liye kudu nyotema natara ye la kulu tanya ning ila kulu lanya fanang koto long.
So I delivered my ruling, and then I made an order that the accused persons be remanded in custody, because that was an earlier decision by a previous magistrate, and the High Court has affirmed that. I couldn't overturn the decision of the High Court as far as their release was concerned.
Bari biringa kuota nganying kele koye bula bari bitung ibe tulam remand le follow ko kiti bunda menu follow tante nyaje ko liya sarto landi nyaming yo adumu bunda le tentete men na kango bondi nola wala kela kango bayno wala nante fana ya landi wonya ko ituliya landi no nyaming.
What was your ruling?
I dismissed the case and then made an order for the accused persons to be remanded, because at that time they were security detainees under the decrees that they have enacted and the detention orders.
Watembo undanga na kito Kenya mendoro nga kito nyimbaile nga baile andum baribitu nata foye sambari man katu otumo kanto nintankada bunda la mutamolle muiti ibeolle la karola otumo.
But Mr. Ture, once that case was dismissed, in effect, there was no reason for their detention.
Mr. Ture, case ni case by dalila taje kota ke purka umare ni ka kango di purkete mura kota ke sindi lagile.
No, legally, ugly as it was, there was a basis for their further detention. Under the dispensation that was prevailing at the time.
Nielua nyina lanya jube wutumo sartolu bekeri no nyaming fereti je foyo kangota apuriye sambari man wo mukolu lanya leti wo jamano.
Because these three gentlemen were already detained under the security, the decree number 3. The State Security Detention of Armed and Police Personnel Decree.
Wotumo sarto la bunda sabanja ome itelia londi decree number 3 itelubeole la muto kono nung meya lonko wenyin kangoli di kabrim police fo sojarolu mutamolu men ya lonko be mutalawulu kono wolu betar la sarto le kono nung.
I don't necessarily agree with the contents of the decree as it was.
Ndefango de mansong decree nyin kolu menu ba kono mansong ila meta.
And I also do not share the opinion that I do not have power to release them. In later cases, people were arrested under the same law, and their names were published under detention orders, and I went ahead to grant them bail. My only difficulty was a procedural one. The issue came before the court, and it was determined. There was an appeal against it, and the High Court affirmed the decision of the lower court. If that procedure had not been followed, I was definitely going to release them.
Amunta kolu belari no nyame wala mnyintiko itelaw kito kola kitido lumenu nata men ya lonka kita façon nyongol leti wo molu ninge la ko bo nyoto nteke bulale yo bari wo tembo telako men waylo atelam ku folo nyinti wo tumo telbe kantoni o tankada bunda la kango men koto wala na mebula bari akola kiti kotango lumenu nata je anyongolu ninga wolu kito lu kenteke bulale.
And what decision had the magistrate court made that the High Court had affirmed?
Kanju the magistrate court molan kiti bundan ni mu kanju malata me yalonko kiti bumba fanam bulata o sar kankili wala no.
The magistrate court has declined jurisdiction on the basis of the fact that they were arrested and detained under decree number 3, and their names were published as persons who were a security threat to the nation, and because of that the court declined jurisdiction to say that they cannot be granted bail. And that was the decision that was affirmed by the High Court, that they could not be released under any circumstance.
Kitibunda ba nyeng High Court ya kangomen londi ya kitibunda duma nkola kangomen londi wala nyintiko nyimolu decree number 3 imutata o kangole koto andu wolem nyinti ko molu memme mutata o kango koto itebula nola yo bitungo dalilo le ya sabu birintel fana nga ko nyimma ntata nga jibe ko wairi wo sarto le belori teliole londi wolem decree number 3 so dalilo le ya sabu imebula no ko lata wole nyama.
So as a lower court, you could not substantially overturn the decision of a superior
That
court.
was the only reason I couldn't overturn the decision of the High Court. But if the matter had not gone before the High Court, and if it was not an issue that was argued and determined by the trial magistrate, I was definitely going to release them.
Ko nyimbe wole nyama katu niaje kitibunda sonta kitibunda ndingula kangola amunta kolu la nyale ya sabu bari natara amanke oti nung tombi ntebe ngela kito kenu nyamin tombi mbebula lale bari wotumo kitibunda do nyimfonga la kangolandi ko nyanta tamala wole yo sabu.
I would like to pose a question for academic debate. The decrees that were passed,
Bela fa nyininkala puru nyininkaro jabi. Yenyin decree men ya blondi.
they were ordinary legislation at the time.
O watola luwa lori ngolo bekeri ne wo watola.
Come again?
The decrees that were passed was ordinary legislation. It was ordinary law. They were below the constitution.
Nyimu luwa let men ya lon ko be luwa bias du malal.
They did not have constitutional force.
Arungi man sarto soro luwa bakoto.
I know that the decrees are now part of the constitution.
Ngalo nyin decree nyin san tangi ben na constitution luwa ba nyi ba konole.
But at that time, they were not.
Bar wo watola itena luwa buku ba nyi kono.
Was it constitutional that they were used to suspend provisions of the constitution at that time?
O watola ke munafa ila labang nyin kamala ko puru ka bandambili ke ining luwa buku ba tema.
Could they have been legally challenged?
Fo luwa to mosi akwo nyin isa no masata no labang fo ya dandulaje bang.
I don't think they could have been legally challenged at that time because
Tembo ngamma mera mosilwa wulindino ulukama purka balang.
the only forum where such a challenge could have been
Mosiwo balambaya wulindino bunda menna
raised would have been in the Supreme Court.
wala bekala nun Supreme Court la bundati.
If I mean the Supreme Court, I mean the last and the third tier.
Ninko Supreme Court wala bunda labango me ya lonko bunda sabanjanguti kitola karola.
Let me clarify this. We used to have a Supreme Court, but it was just by name. That Supreme Court was the High Court.
Wo nkafale nun Supreme Court bari tole mudrong wo kiti bunda wala High Court kiti sandong.
We had the Supreme Court and the Court of Appeal.
Na Supreme Court soto bari nga kiti sainkam bunda fanan soto Court of Appeal.
The Gambia's last court then was the Privy Council.
Gambia la kiti bunda labango wo tembo kafujele Privy Council.
The only place where that issue could have been ventilated would have been perhaps the Privy Council.
Wo konyi mosa abonyoto damen ka jaba kese woto wala woto bakela Privy Council letunu wotumo.
But going to the Supreme Court was certainly very expensive.
Bari kata Supreme Court wo tembo wo bakela ku kolengol tinu wotumo adabe abakole ala.
The Court of Appeal at the time exercised jurisdiction on constitutional matters.
Katu kiti sankam bunda nyi wotumo ka kolu menu tamandi wala mu constitutional la kolu velari nyame.
But this was not in relation to matters pertaining to legality of legislations vis-a-vis the Constitution.
Bari wo mantara dendi kol la men ya lon ko lebe dendi loi lu lanya la sako kol men ya lon ko letata constitution o nyim fangoma wala mbanko la sarti buko nyi.
The reality we were faced with was that we only had the Constitution just in skeletal form because the most vital parts of the Constitution were suspended.
Ntelunga nyatili nu menna wala mku kolengo katu o tembo constitution o nying kukum malu menu ba ko non telisi men sin teli sembentu ya nu ngotumo yewlu be bondile nu ngotumo yewlu tong.
And the status of each and every decree was that insofar as it is inconsistent with any provision of the Constitution, the decrees will prevail and override the Constitution.
Adu wotumo ko membe kering wala mnyinti wo decree o lu menu ye londi wo nya. Nani constitution wala mlua sarti bukuba banko katanu menna nani wala sarto lu benta daoda constitution nyina ko wala banko la sarti buko nyi kawla ko lu landile decree nyina ko lu kawla tamandi kalo wala.
The decrees were not lawful, if you ask me. They were not lawful, but it was that order that gripped the nation, and country was being ruled under that.
Ninka o dikrilu imanke luati de in andu ning luamanta. But bitungo tembo membe caring kamani sembo wale yolu londi wala na ikatama nungolela.
Mr. Precisely, I just wanted to agree with you there because that was the question I was posing to you because the Constitution at the time was the supreme law of the land. You could not have had lesser legislation which attempted to suspend its provision. So it was clearly unlawful and it could have been legally challenged, provided obviously that the right circumstances were available, which they were not.
You are perfectly right.
Amonta council kama nyinin kaja wala mnyinti ko na kumnyinin karo fon koto moleti yemen jabiteng kato tembo wo dikriolu bankola loi sarti buko nying asi balanno le wo dikriol la wala ke bay bari bitum wairi anata findi ko wo dikriol wo tembo sembo dita wollela ka tambi bankola constitutional fon la lotan kangolu la wo dalilo le asabu.
But the scenario we are faced with is that the son becoming much older than the father. So decrees were, they couldn't have, in a normal setting, by any stretch of imagination, they couldn't override the provisions of the Constitution. But that is the whole idea of a military government. Wolu malodula soto sembe dula tela taran dula tela niani na constitutional la bar bitum kwal nata la nyaming amonta menu be steering menu be mararo bundala wolu yon wolna nata o decree olu fisiandi ke sembentu ya ke tambindi bankola constitutional la lotan kangulula.
Thank you very much for that.
Thank you. And then
do you know what eventually happened to them?
They were escorted to Mile 2 prisons, and that was the end of the case.
Ye dandang ye samba Mile 2 kasola kuonye ndandula ketawolet.
And then I think it was the same day I was sacked as a magistrate.
Na mera ate ulunkilung fana yente bay kambondi na palaso to magistrate.
The following day I got my letter.
Asomo lem yenna letter odinna.
I was dismissed, and the dismissal was from the office of from the Personal Management Office, PMO.
Andu yembay biri letter onyina tinye aketako kaito nying abota do kubunda lela memmarta banko do kulalu bela kafujele Personal Management Office wala PMO.
And all it stated is that we have been directed to dismiss you from the service of the Gambia government.
Adun kango membe safari nje wala mnyintiko ye kango le di itolu fanana puri yente bayina do koto kabon Gambia man sakunda do kubundala.
So I had to write a petition.
Tunata kaito safe wala mnyama memu kolu sainkan wulindi kaito ti.
I addressed it to the head of the junta, and that's the chairman, Yaya Jammeh.
Nga letero men safe wonya nga ki junta sojar bunda la kuntonkole utumo wole mu Yaya Jammeh fangoti.
Can you tell us why you wrote directly to the head of the junta instead of addressing your concerns to PMO?
Ya sabu foi sa fono nya dalilo me ya sabu yele taro nyin safa andu yaki me wala juntan kolla juntan la nyaton godi imaki me mola me alon ko wala marling Gambia masakunda do gulal be la nyaton ko imaki we.
Now, the following morning, the following day in the morning, I was called to say that I had a letter, so I went to the High Court, and that was where I received my letter.
Asomo le mi yen kumandi ko nga letter o sotole bitun data High Court wotembo le mi letter o dinna.
I then went to the master, and the master said, "Let's go to the Chief Justice." So
data master ya master kongata Chief Justice ya.
But by this time, it was Omar Al-Ghali who was the Chief Justice.
But Omar Al-Ghali atelom Chief Justice tinu wotembo.
But he was the one who said, "What happened? It's not right," you know. But there was so much fear in him.
Bari atele nyumfanya menketa anin silo manta amanke kutilindi muti.
So
bari nak memba kono utumo atefanambe silandinne utumo.
So he asked me to write a petition. He told the master of the High Court, then Usman Jammeh. He said, he asked me to write a petition and give it to the master so that he can look at it, to vet it before we forward it to the Office of the President. He expressly said I should write a letter to the Office of the President because as far as they were concerned, Judicial Service Commission was not involved in it at all.
Kato ate Mr. Algali atele nata nyin kango fonye pour nga letro safe me ya lonko wala munte fanana kungola nyatili nya letro ti petition konsia safe yo barbito ako ninga safe nsa di mastala mem marta kito bundala otumo ka fayna Usman Jamme ni o letro nyin jibe aya yirika otumo isina tentendi kaki president la office oto.
Can you tell us how you were appointed?
Safono nye yeta do kola nyadi.
I was appointed by the Judicial Service Commission, not the PMO.
PMO mandeta do ko la Judicial Service Commission wala mkitindir bundala kafu sembe mabati bunda banyi wala enteta do ko la.
PMO has no authority over my service.
PMO man ka wo kan soton tela do ko la karola utumo.
In fact, act of PMO even directing that letter to me is also unconstitutional.
Andu hani PMO law letero fongo ka letero bondi tella karola ka kintea ani sartolu manta nyola.
So, like he advised, he said I should write a petition. I prepared a petition. I brought it to the master, Usman. When he looked at it, the very first paragraph, he laughed.
Waira ta kunga letero safe nte fana na kolu menuti nga letero safe petition akonsa di mastala nga di mastala briwe letero nyinna borindi follow nyin jube dorong ajeletale.
He told me, don't you realize we are dealing with a military government? I said, but if you ask me to write, I'm just expressing my mind.
Akonyam feta malon ko inin sojar man sakundale betilindi nyola teng ngai ha mambala wala bari nte fana ko membe nsondo mokono nka wala fintindi teng.
Sorry, Mr. Ture, can you just give us the contents of the letter in summary?
Letter on yinka sutiandi don foi safono nye kuma kan men safeta kono ba.
Would you have a copy of it available?
Letter on yina copy be bulu jande ba.
I don't have it here now. I passed by my office this morning because after the change of government in 2016, I filed an action against the government to get a constitutional declaration that the dismissal and the subsequent termination, because I was dismissed and then thereafter later in 2000 I was also terminated, were unconstitutional. So I went to the office to try to access the file so as to bring a copy along, but I couldn't see it. But I'll get it for the TRRC later.
Bisomanda ntambital na office la pour nyin kamala nsika mbulo sila kaito lukang meya lonko nte fango brimman sakunda falinta nun 2016 nata savero kele kaita ndi kolu menu tamata ntela karola menu ni silo manta nyola menu ni sarto manta nyola munta nga samaniro ke okotole yo bari bitun lafta mbulo lala no kaito le kam fancy file nyin soto ba brinna tan na office oto nga kata nyawnyandi man mbulo man lano kaito lukang bari mba kata la ngana fere ke ngaw kaito lu futandi TRRC ma nyatondo.
Were you able to find your appointment letter or your termination letter?
Ile ing bayri letter on waranto yeta letter on men na foi nata na jela bang.
Yes, that's what I am saying. I have them in my case file, personal case file, that in the action that I instituted against the government. I'll make copies available to the commission.
Ambole fokanteng ibebe na o file le kono na file ba nying yo bari mbe fere kelale mbulo ela o kayto lukan ngesa inka yelema nga fere ke han foye futa TRRC ma.
And just out of interest, how did the institution of that suit go?
Puru sulo kan rondong o ilo samanero ni safero nying akeno aketa no nyadi le.
The decision went in my favor. The dismissal and the termination were declared unconstitutional. They were, in fact, the angle from which I approached it was that they clearly amounted to unwarranted interference in the administration of justice.
Bitumbiri ya ko jube ya no masata ntele nata ganye akonyi nkono katubiri ya alanya aninkolu Kenya jibe itataje ko yekolu kemnyu nyaming ye tamandinu nyaming anin sarto manta anin lua manta nyola wodalilu le ya sabu ntenata kango soto je menketa to nyati nteganyeta akonyi nto.
So this provides clear judicial precedent of interference in the judicial system by way of unlawful dismissal.
Certainly.
Please let's go back to the contents of the letter. I'm particularly interested in what actually made the Master of the High Court, Usman Jamme, laugh.
Silang ngata letter on yindo kuma kama meyalong holbe fururu ni letter on yingono katunga yang sula bagal pur ka long mune ya sabu kabri master membe nunje ba fala me Usman Jamme bringa damra ka letter on yin karandrong aya borondi follow yin karandrong a jeleta lefta ka wota lolo.
He was of the opinion that the letter was too radical.
atela jero munyeti ko letero nyin kuma kan lumenu bije iketa kuma kan bambandingol leti.
He asked me to rewrite it. I did so. But when I brought it again, he was of the same opinion that it was too radical.
Akona ta fonye nga sa inkan safe nga kangolu do nga kuma kangolu faling. Na ta sa inkan safe nga kuma kangolu faling bare hani o fanang biringa na ta konyen hanimbi ku kilingola bijede.
Do you remember any particular words or phrases you used?
Hakilo samu no yemu kuma kan sifa le keje memba ila mira loro memba sabu atak ba fala ko ila kuma kan nyin chambo warda bagale bambanda bagale.
I can't remember anymore because the 2 drafts actually remain with him in his office. I'm sure he must have destroyed them. He was the one who finally toned down the letter. And then that was the version that we sent to the office of the president.
Hakilo te wolu mutano la katu kumeri ngolombari nyin kaiti fulo lube ngamen folo safe nata fulanja o men fanan safe wolu be labanta atele bulokono bari ate fangole nata safer ke afaye ay menki bitun kolu nata wole nyama.
After about 12 days, I was called by the confidential secretary of the Secretary General.
Secretary General.
I went to the office of the President. State House.
State House.
I was given a letter reinstating me back into the service of the judiciary.
Who was the
SG at that time?
SG, Secretary General to Warola.
This was WADA.
Do you remember his first name? Was it Mustafa Wada?
Mustafa, yes.
Mustafa Wada.
I remember before they gave me that letter, in the intervening period, he called me to say that I should send a second petition.
Wo wuche onyin kono janning kumandir flanja ngo bekela wala nyim fonye kongata nga letter flanja ngo safe nyanta menkila.
I think when they start over the petition, the issue that was raised by the Attorney General then was that I should have committed Mr. Jobate for contempt of court rather than dismissing the case.
Amunta birite lusita ko nyin kunna ya jube iko nyanta Mr. Jobate dundila nun kito nyin kono le ka foko amunta te jututa kiti bunda nyin nale wole fisiata nun ko nyin mumeo bay.
Did they tell you on what basis you should have cited him for contempt?
Well,
in the course of the arguments from both sides, there were ethical issues which were observed on the side of the prosecution. So part of it filtered in my ruling. That was the reason why they said that I could have adjourned the matter and dealt with the prosecutor by exercise of the powers of contempt rather than striking out or dismissing the matter.
Apart from the Attorney General, who else sat on that petition?
Attorney General,
I believe it was the military council, and the Attorney General was a member of the military council.
And who was the Attorney General at that time?
This was Mr. Bite, Musa
Ngari Bite.
I sent in the second petition explaining why I could not have committed Mr. Jobate for contempt. Mr.
Jobate la ka foko ajututa kito nyinale.
And after a discussion on that by them, then that was how I was reinstated.
Ngalon ko birital fanglu sita ya ko jube kachata akwala inata kamben dalilo kang puruka jako yenta murundi na doku wokang yenta.
It's interesting because at the beginning you told us that the effect of some of these decrees was that it suspended legislative as well as judicial powers. And in this case, it looks like the council is sitting over your case as an appellate court looking at the merits and demerits of the case.
Nyabo warta baga ko man don yafa mole nun janko ni decree ni keta loi len men ya lonko loi la sarti buku ba ni anin loi kiti bunda ni na sembo ni awol be talale silan afere jan juntala mol keta mol de me yanko wolle be siri tela ko ibe la ko ni kiti ka mo sa fono kiti bunda mul ngam je fana de be tela ko ni kiti ka.
Yes, that's absolutely true, because the Chief Justice, with all due respect to him, and may I pray for the Almighty to give him, how do I put it, Jannatul Firdaus. But the entire judicial system threw in the towel. They didn't want to take any single decision over the matter.
Who was the Chief Justice?
Kenya jube akonyi mbe menu sita kunto katabula atenyim fangala memu ko kunton kote alama nema nin kafarkelae itelbe na tay bulo ku nyin ko nyin konole imam pare kantaman laje wo tembo ko afindita nu nyami.
So all the power was concentrated in the hands of Jammeh.
Kato tumo sembo be na ta dun jamme dam manne bulo kono.
Who was the Chief Justice at the time?
This was Omar Al-Ghali at the time.
Omar Al-Ghali atelom kolu nyaton koti wotembo.
I must also say my sacking was the first interference
mbenyim fanam fala ko kante bay wala keta bulubula foloti
by the executive
nyaton ko sojar nyaton ko la man sakunda e menta
in the judiciary.
Ke dabula wala ke bulobula kitindir bunda la do ko
And it generated a lot of condemnation from the United Nations, from the Commonwealth, so many of these organizations.
Andon dunia la nyin kafubalu bena ta wo ko doya United Nations ana bunda ko tangulu ibeye wo doya ka foko sojar roli apare sojar man sakunda ye bulobula kiti bunda la do ko kono.
And I remember to give Sadauda of blessed memory occasion to condemn the junta. He said, now it's clear that we have gotten evidence that the junta is not sincere to whatever they are saying.
Andu kamfanang tala Alhaji Sadauda banko nyatun ka folo alama nema nin kafar kelaye atafanan nata doya roke akola ko silanga seneyata le kaitandi molu la ko nyi soja roli ye memfo ko itelube mala nyamin woning itelube keka nyamin saying ifatatale.
So when the dust settled down, I was moved to Mansakonko.
And before the dust settled down, did anything in particular happen to the then Attorney General, who had made some suggestions as to what you should have done in the case?
Janding kankan nyimbe tenkunna fo kuna na sotola menketa memunu Attorney General to wato la menarana fo enyanna kule mentaman la case nyindo fo kuna na kala.
Well, by coincidence, the day I was reinstated was the day he was sacked.
Betun kolu benta nyaming asike amunta ibenta le katu lumme yente murundi na do kola ulunna yate bay do kola.
Was that coincidence or executive plan?
Well, let me say by coincidence.
It's strange that it was coincidence if his advice was disregarded, you were reinstated, and then he was booted out.
That's how we saw events.
Yete murundi na yate bay ate min me alon ko yate ate yamaro dinu alaw yamaro nyingi mala yamaro ta sire nata ne yate bay yete murundi
abeto de ko lata wala nyama.
Okay, thank you very much, Mr. Ture. I believe it's now time for the break. We'll just leave it here and then go on to the break and come back. Mr. Chairman, I hand over the witness to you.
Yes, indeed. Coincidence, extraordinary. Thank you, Mr. Ture, and thank you, Council. We will take a coffee break and come back at 12:20.
Thank you so
adjourned.
much.
Thank you.